Hey, everybody. Welcome to day 2 of Estate Planning Awareness Week. I'm Terrence Quinn, the chair of the Real Property Trust and Estate section of the National Bar Association, a fantastic organization that I've been a part of for some time now, the country's oldest African-American bar association, period. And it's a dynamic organization. Anyway, we're excited about what's going on. As I said yesterday, for those of you who were here with us, the State Planning Awareness Week is a week that was put in place by our government some time ago when our legislatures, our president, the people in authority at that time were realizing just how important it is to make sure that people are aware of matters associated with estate planning. Our section in the National Bar Association is dedicated towards two things. Number one, making sure that we were putting people in a position where they had great information so they know what to do. But the other thing that we're committed to as a section in this organization is making sure that our members, the attorneys who actually practice in estate planning and property, are also up to speed, well-equipped, well-trained in matters associated with estate planning and property. So that's what we're doing today. Day 1 yesterday was all about wills and trusts and property matters, and was for the community nationally. Today is all for attorneys. We want to make sure we give you great information. And as a matter of fact, we wanted to make sure we provided information that wasn't only for estate planning attorneys. We wanted every type of attorney to hear how and why it's important to include information about estate planning, or at least approach your practice with estate planning and property in mind, because all of your clients are dealing with both of those things in one way or another. But I'm not going to get into that presentation because we have two great experts, colleagues of mine, members of the National Bar in our section, who are going to be training today and talking about giving 20 tips for all attorneys as it relates to estate planning and property and everything. But before we get into that, we are privileged and honored to have one of the board members of our National Bar Association. He's actually the vice president for sections and divisions. So he's our boss under the bigger boss, who's President Carlos Moore, who was here yesterday. But Vice President Lamont Bailey is on. He wants to greet you all from the National Bar Association. Lamont, can you take it over, sir?
Surely, Chair Quinn, members of the National Bar Association, and all attorneys and all those who are on this call. I bring you greetings on behalf of our National Bar Association President, Carlos Moore. As you heard, my name is Lamont Bailey, and I'm a vice president of the NBA, and I'm also a dues-paying member of the Real Estate Trust and Estates Law section, this particular section. The National Bar was founded in 1925 and is the nation's oldest and largest national network of predominantly African-American attorneys and judges. It represents the interests of approximately 68,000 lawyers, judges, law professors, and law students. The NBA is organized around 23 substantive law sections, of which this is one, 10 divisions, 12 regions, and over 80 affiliate chapters throughout the United States and around the world. President Moore's theme this year is Stand Up NBA, an acronym for strong, tenacious advocacy for a new deal uplifting our people. Strong, tenacious advocacy for a new deal uplifting our people. I would be derelict in my duties if I did not solicit membership in the NBA from those of you who are not members. This webinar is just one benefit of being a member of this association, of which there are many. I could sit here for an hour, but I will not, because I only have 2 minutes to speak. But I thank you on behalf of the NBA for your participation and hope you enjoy the program.
Vice President Bailey, thank you so much for taking time. I know you're busy. I know you have a lot going on, and we greatly appreciate you taking time on behalf of the NBA to come in and greet all of our participants and guests today. Feel free to stay on, of course. I know you're a member of this section and everything. And then, of course, if you have things that you need to get to, feel free to excuse yourself as well.
Thank you, Mr. Chair.
Yes, sir. Yes, sir. But we're going to turn it right over to the presentation because I don't want to take away from the time that these dynamic attorneys will be sharing. Today we have two. We have Amy Griffin and we have Aquanetta Betts. Both of them are going to collectively give us 20 tips on how we can be better attorneys in general, and I'm adding that to it. They're going to share with us what we need to know when we consider estate planning and property in whatever practice area we find ourselves. And let me, with no further ado, turn it right over to Amy and Aquanetta. Could you all please first introduce yourself to all of our guests? Tell us who you are, what you practice, as well as where you're located, and then just jump right into your presentation. We'll go to you first, Amy.
Certainly. Thank you so much, Chair Quinn, for having this event, because I know that is one of those things that are truly is essential, the things that we don't get to talk about enough. So my name is Amy Griffin. I am the principal of the Griffin firm. We are based in DC, Maryland, Virginia, and we serve in Pennsylvania and Massachusetts. We are estate planning and business succession planning is our URL is yourestateplanningattorney.com. I'm going to share my screen, and I actually beg for forgiveness. Oh, in addition, I am the founder of the nonprofit, the Association of Black Estate Planning Professionals, because we know we're better together. But I'm going to share my screen, and I ask for forgiveness about my technological struggles in advance, because I know that I always end up going the wrong direction at some point. So, but I'm excited about this opportunity to go through my 10 points first, but I also get to share the fact that we are an all Black women firm where we have 9 attorneys and a support system for all Black women. And so we're better together. Right. I am a lifetime member of the National Bar too. I want to say yay, yay, yay. But one of the things that estate planning attorneys especially think about, another we should all be thoughtful about, is attorney-client privilege. And as we were talking about and thinking about those things that we can get janked up about, especially, and I'm taking this from the perspective of when it's a collective or a consideration. So estate planning is one of those things that impacts not just an individual, but a family. And oftentimes with that in mind, we'll have families come together to talk to the attorney or the professional that they're working with for financials or whatever. But we need to be thinking about when we have a family member come to us to have this conversation about the estate planning, what are the concerns? What we know is attorney-client privilege is only when there is when there's a one-on-one conversation, that our clients have the privilege of having the confidentiality with the attorney only when they're the only other person in the room. When you bring someone else, when you bring a child in, when you bring a financial professional in, which is often the case for so many times when we're having this conversation, but it breaks the attorney-client privilege. We need to be mindful about how do we structure it such a way that we are having the conversations in a way that maintains our client, our privilege and the confidentiality. So we need to be thinking about it at all times. We need to be also in this era of Zoom, where so many of us are operating remotely, that we need to be thinking about, is there somebody else in the room? Is there somebody else who can overhear the conversation? And so therefore, we need to make sure that our attorney-client privilege through the model rules is maintained. And if it is not, we need to take the responsibility of explaining to our clients what this attorney-client privilege is, as well as what the sacrifice includes. Because if indeed we're unexplained to them, they don't know what they're sacrificing. They don't know what they're giving up. So it is our responsibility as attorneys to move forward and explain to them what the confidentiality is and what is at risk. We know that there may be occasion when there is a need for litigation or there's an opportunity for litigation that we can only preserve what we have. So I encourage people to be thoughtful and don't take lightly attorney-client privilege. Testamentary capacity. Now, what we are thoughtful about is, what's really important is, what is competency? But specifically, I'm going to bring this, I know they were supposed to be talking to multiple areas of practice, but I'm going to focus this on testamentary capacity for creating a will and a trust, right? And the power of attorney, because it's a very different standard. It's a very different expectation. For us, when we're practicing in estates and trust, we need to be thinking about, is the person that we're talking with, if they're able to make a plan that is based on their testamentary capacity. It doesn't need to, they don't need to necessarily know the president of the United States, they don't need to know the government, but what they need to know is what we say is the objects of their bounty, right? Do they know what they have? Do they know that they're a multimillionaire? Do they know that they're that they have houses or a house? And then more importantly, do they know who their family members are? Do they know who their heirs are? Because they don't need to have a great, huge, large explanation, understanding so many things in the world, but we have to have very focused conversations. And a lot of times people come to us, what we know is oftentimes people come to us later down the line. They come to us when things are potentially questionable. Now, we want to make sure, and we need to make sure that the people with whom we're speaking are able to evidence their testamentary capacity. And so what we need to be thinking about, what is in the best interest of our client to prove that they represent what they represent, that they are capable. So what we may need to be doing is, there are some cases where people videotape the execution of the documents, and then with the precursor of asking questions. So it's asking them, do they know who their the objects of their bounty are? Do they know who their loved ones are? And if so, if they can answer it in a way that proves who are the people that they care about and what the things are that they have, that's one thing. And additionally, what we often encourage people to do is have the witnesses who are witnessing the signatures, that they write an affidavit, that they speak to the testamentary capacity, because a lot of times when it comes down to the time to prove that the individual had capacity, that the witnesses aren't able to be found. So I encourage people to create that affidavit now, because oftentimes the probate court will ask for the affidavit later, then we can't find them. So many times that the witness can be the neighbor, many times the witness can be employees. But if we can't find them to later go on and get that affidavit, it's prudent for us to get the affidavit ahead of time, or have that documentation to reflect who indeed is able to substantiate that the client had the testamentary capacity. Again, it's not the same standard for all matters, but for the testamentary for estate and probate is to make sure that they understand what the assets they have. They don't need to know the stock value at that moment, but they need to have globally an understanding of the level of assets that they have, as well as who are the people in their family that they care about. Because if we had, for example, a person who didn't remember all of their children, and therefore they disinherited someone that they didn't remember, then they can, that disinherited child could have grounds to contest their estate plan. So we need to be thinking proactively about how do we protect that which we've created. I want everyone to be thoughtful about, when does the attorney-client relationship attach? When we talk about, so often, many of us, especially estate planning attorneys, do workshops, we do presentations, we have consultations, and then oftentimes those people will ask us questions. And we may choose that we don't want this person as a client. I know that there are times when we are saying, oh, no, this person comes fraught with a whole bunch of issues. But we need to be very clear with the person with whom we're having a conversation that this is not necessarily, especially if I'm doing a presentation, this is not legal advice. I'm giving you general information, education information. So the attorney-client privilege does not attach, because when that relationship attaches, we both create a level of liability in relationship. So we need to be very thoughtful about what is it that we need to do to make sure that that client doesn't, that person, not a client, that person does not believe that we are now a client. We need to build that relationship, build the structure into how do we make sure that it doesn't indeed happen. So what we need to do is consider, how do we make sure that we have an understanding, a process and procedure to say that, one, the disclaimer with all of our presentations to say that, no, this does not create a client privilege. The consultation does not create an attorney-client relationship, but that when we do, that we are very, very broad in making sure that we are erring on the side of caution, so that we say that, oh, no, 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 no. We can follow up and say that when you have an attorney-client, that you will be notified with an engagement letter or whatever, and we'll talk about that further on, but making sure that we know that that the consultation does not create. And we identify that at the beginning when we have the initial consultation, and we inform someone or even set that appointment up, that we say this is a consultation. This does not create an attorney-client relationship. So we make sure that we are clear as much as possible about when we do and how we do, and we'll talk about that in greater length. What we know is this is a picture of a blended family. Is a married couple, is the conflicts of interest. When we learn that in almost every bar exam, we talk about the conflict of interest. Whenever there are two people that you are engaged with, and for often it makes sense that we serve a husband and a wife in doing an estate plan where all of their assets are joint and all of their children are jointly conceived, and it makes sense for them to have one attorney. However, irrespective, there is an inherent conflict of interest. When you have a husband and a wife, even when there is not a side chick or a outside blended family, we need to be thoughtful about the fact that there is an inherent conflict of interest. And what we need to do is, as attorneys, make sure that we have them waive that conflict in writing. What we also may need to be thinking about is identifying the areas where there's conflict. So often what we know is, let's say we have a husband and wife and they have no children, but then they have joint assets. And what happens if one predeceases the other, and or they die jointly? Do we make sure that those assets are spread to both sides of the family? We need to be thinking and talking all the way through what is in the best interest of one versus the other. You need to identify what is the standard. So if I am talking to the husband, I am speaking with his interest in mind and being thoughtful about that. When I'm speaking to the wife, I'm speaking to her with their interest in mind. But we cannot act, we can't have the husband bring you aside and say, oh no, I do have some children that we're not identifying here. We need to be thinking about how do we let them know ahead of time that this is an open playing field. Anything you say to me, you're saying to both of us. I can't keep secrets from one versus the other, right? And so we don't have meetings that allow to have one spouse versus the other. We've had many cases where you can say, no, I'm sorry, I can't serve you. Well, because we've had circumstances, and honest to God, we can't make this stuff up. When a husband came in with his side chick and identified, this is where I want to do the estate plan for. But we need to be thoughtful and planful, because it's our license on the line, to make sure that we operate in all decency about how do we make sure that the client that we're representing understands the conflict as well as waives that conflict. One of the things that we're, especially as we do estate planning, part of that is doing pre and post nuptials. That's one of those cases when, yes, they can waive the conflict, but you need to be being thoughtful about if you should have them waive. You should be very thoughtful about if it's not in your best interest to make sure that they get separate advice. You can draft the document, but they both might want to be thinking about having separate advice about that pre or post nuptial, because making sure that their interest is indeed covered. And especially in Maryland and other states, we think about the elective share in estate planning. Being thoughtful about how do we plan for that spouse, and being clear about sometimes when you draft the estate plan, being clear that you can't do the probate matter if something were to happen, right? And there is probating required if there is that conflict, because having the elective share especially sort of creates an opportunity to go against the stated wishes for the surviving spouse. So you might need to be very thoughtful about, no, we can't operate in that way, and let them know ahead of time, so that, again, we want to be clear about how do we preserve the rights and the privileges of each testator. One of the things that I know that there is, we should spend a whole lot of time with as we're building a practice, and I don't have time to really talk about the huge, huge benefit of a great, intense, robust intake process includes. Now, I know that there are a lot of times that we need to be thoughtful. I know when we first start out, most of us have what we call threshold practice. The practice area is anything that comes over the threshold, and we'll take any client that has a check in mind. But then as we get more sophisticated and we realize that all money isn't good money, we get to be thoughtful about, we need to screen our clients to make sure that what we're providing is a service that, one, that will keep us from having our license revoked because of the competency, as well as sometimes it will be working far harder just because of the client that we've received. So the intake process helps us clarify what is it that we want to do, who is it we want to work with, and really what's involved. Now, I will encourage you to be very thoughtful about and there is a balance, because we don't want to get a whole bunch of information from somebody that we're not going to serve. We don't want to get their social security numbers, their bank accounts, all of that, if we are going to choose to not serve them. But we want to get enough information, for example, in a probate situation, if it's going to be that all of the children are fighting, and it's going to be a huge, it would end up litigation. I want folks to be very thoughtful about what they're entering into, but we don't want to sort of, again, wave off so much information that we've got all this information that could put them or us at risk if there was ever a cyber thing for somebody that we're not going to serve. We want to make sure that we have enough information to make an informed decision about our ability to serve them, as well as enough information to say no, thank you. But getting that intake process, we know that there's a lot of it, and it can take a whole lot of time. But what I encourage people to do and be mindful about is making sure that we leverage our technology in this case. One of the things that we know, there are a lot more companies that are coming out with great intake lead magnet kinds of things. But just because a lead comes to you doesn't mean that you want to serve them. You'll see all of these ads, especially as lawyers, we get bombarded with, get 50 leads a day. That doesn't necessarily mean that we want them. So we want to make sure that we have that mechanism in place that we can determine if this is indeed a good lead for us, if it's the client that we have, and if it's within our realm of understanding, so that we can appropriately serve them, right? Engagement letters. What we want to encourage people to be thinking about is making sure that we have truly effective engagement letters. That number one that we talked about, when indeed your attachment is, your attorney-client relationship attaches. Now, be very specific, because that's also another way in which we can end up with being malpractice, being really clear about what are we engaging someone for. Now, there are many jurisdictions that have limited attorney representation. So it can say, I only want to represent you for this little part of the process, as opposed to until it's completed. Because there are sometimes it is about that you find out that you're beyond your scope. And the first part is going through that initial discovery in the relationship to determine when and if this is an appropriate relationship. And then when you are mindful of what is it that it requires. So, because as we know in contract law, the engagement letter is the offer. And we get to identify very specifically what is it that we are offering, and what is it very specifically what we are requiring of our client. If it means that I am not engaged, even if you sign it, but you haven't given me the retainer, also being very specific about if you are, you've given me the money, but there are also these other documents that are required for you in order for us to move forward. These are the things that we need to be able to be thoughtful about, what indeed it is included in the scope of the service, as well as what's important in identifying the engagement letter is the fee. So if it's not just a retainer, how often am I going to invoice? How much am I going to pull from the retainer? And when is it, if you don't pay, what are the consequences if you don't pay in a timely manner? All of that stuff is ought to be incorporated in the engagement letter. And one of the other things that we need to be thinking about is the termination of the engagement. So if indeed we're going to say, because even though we know that many jurisdictions require, if we're in, especially in litigation, going to the court to ask for permission to be removed, but we still want to identify what are the conditions for removal or termination that we identify. And we'll talk about that further as we go on. But the engagement letter should be your get out of jail free card in some levels, right? How I can start the relationship and how I can end the relationship. It needs to have a great level of specificity in determining what is it that I'm requiring, what is it that I am creating in order to build that relationship, right? And what are the requirements? Because so often, and if indeed one of the things that I encourage people, if your scope changes, to revise the engagement to the letter, so that make sure that you are staying current, so that what we're providing, what the service you're providing is truly reflected in the engagement letter. Malpractice. Now, all states don't require that there is a, actually, let me back up what the engagement letter, one more thing is, if you've chosen not to work with the client, make sure that you create a non-engagement letter. Let them know that you have chosen not to work with them. A non-engagement letter can also create for you that clarity, because we don't want them. I've had people who want to continue to call and refer to me as their attorney when indeed that is not the case. So we're going to be thoughtful about creating the non-engagement letter to say what it is, what they presented and what is you chosen not to do, so that there is no confusion. There is complete clarity in serving that we are not going to work together. Malpractice. Again, many jurisdictions do not require malpractice insurance. However, what we know is, especially estates and trusts, this is the fourth area of practice in number of malpractice claims, right? Malpractice cases. So we encourage people to be very thoughtful about making sure that you have malpractice insurance in order to go forward. And one of the things that we identify as one of the reasons for the malpractice is competency, right? So often there's a breach of trust, which again is represented in the engagement letter. If you do something outside of the engagement letter, you can be sued for malpractice. If you don't do everything that's incorporated in the engagement letter, you can be sued for breach of trust. So I encourage people to be very thoughtful about who is it that you are serving. Once again, as we talked about the testamentary capacity, you can be sued by a third party who says that you did not, that the person did not have capacity. However, you move forward in completing the estate plan for someone who didn't have capacity to do that, as well as if that someone, if we know that there was undue influence, if you knew it. So let's say, for example, we had someone who came forward and said that this was one of those, because we know that we get those calls often, that someone is either on their deathbed or in the hospital, and so that they want to have their estate plan done quickly. Now, mind you, if it's that Uncle Charlie who calls you to say that we want to have that estate plan done on the deathbed, and all of a sudden Uncle Charlie is the beneficiary or as well as the executor, and the children are disinherited, be very thoughtful and careful about moving forward on making sure that you indeed have all the undue influence considerations taken into consideration, making sure that if indeed we have all of those concerns identified, so that we're making sure that we are planning to avoid against that malpractice lawsuit that's coming. Termination of representation. Now, one of the things that we know, especially when we're thoughtful about estate planning, is that things change every year. I know that there's a huge scrambling at the end of each year where the laws change, and making sure that people know that the best interest of our client is reflected in the documents or the service that were provided. Each of us know, because we're lawyers, that laws change all the time. And what is our responsibility to go back to those clients that we have created an estate plan for that work during the time that it was created, as opposed to now when the laws have changed. What we need to be thoughtful about is if we create a letter that says, I have terminated my representation for you, and if you want to re-engage me, that's fine, but knowing that I no longer have a duty to you. So therefore, there is no longer a need or concern about misrepresentation or malpractice because my representation with you has now ceased. So again, that's why one of the termination of representation letters exist, being thoughtful about creating. And then finally, one of the things that I have been mindful of is collaboration versus competition. This is one of the greatest examples I think about as an estate planning attorney, is that, and the reason why the National Bar Association, we are better together. One of the things that I remember going through law school or getting my LLM in estate planning, the conversation was, I don't have to compete against any other estate planning attorney in the world. 50% of Americans don't have an estate plan. We just have to compete for those people that are without. So what we know we need to do is use opportunity for education, use opportunity to collaborate with our strategic partners, be it financial advisors, other estate planning attorneys, other attorneys, to build out capacity. What we know is, in my mind, is estate planning is one of the things that we need to do to bridge the racial wealth gap, one of the things that we need to do to create a greater capacity in our Black community. So as a Black estate planning attorney, we know 30% of Black folks have an estate plan. We don't have to think about how do I need to compete with my brother and my sister. There is, as opposed to looking at sort of a scarcity mindset, we need to look at it as an abundance. We have 100% that we need to be going for and building regularly, right? So we need to increase our capacity, because as I say, with high tide, all boats rise. We need to be thinking about how often we can use education as a tool, remembering that our people perish for the lack of knowledge. So if we are thoughtful about how do we bridge the knowledge gap by encouraging people to know and do and be, then we can bridge the racial wealth gap by creating, assets that go from generation to generation, strategically planning, not just with other attorneys, but other financial advisors. So I encourage folks to be thoughtful about how do we to create collaboration and network, because we know that it is through our referral sources that we're able to be the most successful. Right. And so that's the end of May. So I'm going to pass on, stop sharing my screen, and go to Aquanetta.
Wow, Amy, that was fantastic. I'm sitting there taking notes. I'll be honest, I'll admit that I don't typically do that affidavit that you talked about at the very beginning when we have witnesses. And if there's a question, what I wrote, if there's a question regarding the capacity of the person who's creating the document, always include an affidavit from the witnesses now, so I don't have to scramble to put it together later. Thank you for that information. That was dynamic. I'm going to go right over to Aquanetta. Aquanetta, can you come on? Introduce yourself, tell us where you are, what you practice, and then jump right into your presentation.
Yeah, well, thank you so much, Amy, for that presentation. I appreciate you setting everything up, and great foundation that I'm going to move forward with. I'm Aquanetta Betts. I am currently the Senior Executive Director of Plan Giving for World Vision, and I also am a licensed attorney here in Maryland. I'm right outside of the Baltimore City area. I'm also licensed in the District of Columbia. And I will share with you, I'm going to pick up where Amy left off, but I'm going to get into some of the charitable giving ideas that we should all know about as attorneys, especially if you're dealing with estates. And even if you're not, if you have another area of practice, it's certainly worthwhile that we know more about this charitable giving and how it actually affects many different areas of your clients' lives and also your lives as well. And also organizations that either you are a part of, a member of, or you may actually represent. So I'm going to kickstart that off with the presentation I put together. And Terrence, I think I've covered everything you asked me to share about who I am. Did I give enough info on myself?
You did great. You did.
All right, perfect. So I'm going to share this screen and start my presentation here. Okay. Now, Amy, you were wonderful in getting us started and sharing some tips for attorneys. And I'm going to put another spin on this. This will be more along the lines of what we need to do regarding our clients and their estate plans. So the top 20 tips, Amy gave us 10, and I'm going to share with you another 10. So this presentation, as I just mentioned, I will do 10, and then Amy, of course, give us the first. So here we go. Here's an overview of what I'll be sharing with you all today. Estate planning and charitable giving, 10 tips for attorneys. I'll touch on wills, trusts, and bequests, the Secure Act, individual retirement accounts, IRAs, qualified charitable distributions, which we refer to as QCDs, and required minimum distributions, RMD. So just hang in there with me. Some of you may be very familiar with a lot of these terms. I know there's a lot right here. There are a lot of acronyms I'm throwing out, but just hang in there. This will all come together. And I think it's really important information that we know more about. The sixth item that I'll share will be about a charitable remainder trust, a CRT, and a charitable lead trust, a CLT. The CARES Act, we'll share a little bit about that. The Coronavirus Aid, Relief, and Economic Security Act, and retirement accounts, beneficiary designations, and proposed legislation. There's a lot of talk right now in Washington and around the country, actually, proposed legislation that will affect the way we plan estates for our clients. So that'll be a bit of information that we all need to be aware of and stay abreast of what's happening with legislation. So tip number one, consider the intent. When you're working with one of your clients, you're preparing documents, we want to think about what are they planning to do? Are they giving something to charity through their estate? Well, we have to be careful when we're actually drafting those documents. So here's a tip. Just know that it is not okay to prepare a document for a client and have something in that document that's illegal or impossible or impracticable to enforce. So think about that for a second. I've actually had clients before in the past that they were looking at putting something in a trust regarding their young minor children. And it was related to who they perhaps would marry one day. So just think about how those things go into certain documents and think about the future and what they may actually end up looking like. They may actually end up in court somewhere. And the same thing happens when it comes to if someone makes a gift to charity. If they make a gift to charity, that gift, think about years down the road. What will that gift look like? Will that building that your client wants to have their name put on, will that building still be there in 20 years? So think about all those things. And there's a way to move that forward if for some reason the laws have changed, or by the time that gift actually comes to fruition, when your client passes away, when that charity actually is looking to receive that gift, a lot of things may have changed. So keep that in mind when you're preparing those documents for clients. The next thing, we're also along the same lines of consider the intent. I'll speak about here in Maryland, we actually have a statute which goes along the lines of a court can actually intervene, and they will intervene to fulfill the general charitable intent of the settlor or the testator. So there's a lot of language there, but just keep in mind that courts will step in, and oftentimes they do, if for some reason a gift to a charity is no longer able to be fulfilled. In Maryland, there was a case regarding a very wealthy husband and wife. They were elderly. I believe they lived to be up into their 90s, and they wanted to make a gift to a local assisted living facility. And this was back in the late 50s, early 60s. But some of this is still good law, believe it or not. But this couple, they wanted to make their gift, and in their documents, they actually put in there some restrictive language regarding who would be able to utilize this assisted living facility. And it would be only for white people. So the assisted living facility, they still wanted that gift, as you can imagine. It was a pretty sizable gift. But the terms of that particular trust, that's illegal. We can't have that sort of discrimination. So consider the intent, and just know that when we're preparing these documents, we really have to think about what your clients are asking you for. And it's not always okay. Just because your client wants something in a document, it doesn't make it okay. Tip number 2, consider the Secure Act. So the Secure Act came about in 2019. And with this legislation, it actually did something that many of us, we've been familiar with for years, the stretch IRA, where there's an IRA, the account holder has this IRA, and they want to leave it to a beneficiary, perhaps one of their children. Well, they had usually, as long as they wanted to keep that IRA, they could. Now, beneficiaries under the Secure Act, they have 10 years to cash out that inherited IRA. There are some exceptions if the beneficiary is disabled. So there are exceptions regarding this rule, but if it's a non-spousal beneficiary, that stretch IRA for all intents and purposes has been pretty much eliminated. So what are the options to provide income for beneficiaries beyond 10 years? Because remember, for most beneficiaries, that stretch IRA is no longer an option. Well, there is something that we're going to talk about in a little bit, and it's a charitable remainder trust. That may be an option for some people. And I'll get into some of the details of what that charitable remainder trust may look like. We're still on the lines here of the Secure Act. The Secure Act had many different parts and pieces to it. But it also, in the Secure Act, it will change the age limits for folks who are able to withdraw or make distributions to charity under their qualified charitable distribution or their required minimum distribution. So the Secure Act was pretty broad. But here on tip number 3, I want you to think about an IRA for a second and think about gifting that IRA to a charity. Now, why am I talking about this stuff? You have clients that come into your office, they talk to you, and they have pretty sizable IRAs. Sometimes, aside from maybe a piece of real estate, the IRA is probably one of the largest assets that they may have. So here's the thing to know about an IRA. If your client is saying, I want to gift my IRA to my child, that's fine. They certainly have the ability to do that. But on the other hand, they also may be charitable, and they may say, I'm also giving to my favorite charity. It could be a faith-based organization. It could be a college or a university. Just know that gifting that IRA to an individual will have tax consequences for that individual. If there's another asset that they're thinking about gifting, for example, an IRA for $100,000 gifted to an individual is taxable. However, if they have a life insurance policy that they also want to gift to someone, if they gift it to that individual, it's not taxed. So looks like I made an error here on my IRA. So if the IRA for 100K goes to charity, it is not taxed. But if you gift it to an individual, it is taxed. So it may be a better gift to give that life insurance policy to that individual, to your child, as opposed to gifting that IRA to your child. So there's a difference there. One gift will result in taxation. Another gift, the IRA to charity, will not be taxed. So some people want to give to their favorite charity. So keep that in mind as you're planning with your clients. A lot here about IRAs, but there's some pretty big assets for many of your clients. So tip number 4, know the age for the qualified charitable distribution. So again, the Secure Act, it made all these sweeping changes in 2019. So if you have a client approaching 70.5 years of age, or they may already be 70.5 years of age, they can gift from their IRA directly to their favorite charity. And that's a non-taxable event to the individual. Again, 70.5 is what you need to look at. So if you have folks coming in there, they're 69, 68 even, you want to keep that on your radar as you're speaking with them, you're consulting with them. So they can make up to $100,000 gift to charity from their IRA, and it's not taxable to the individual. However, there's one hitch here. You have to have that IRA QCD go directly from the IRA administrator to the charity. You can't have it go to the individual at all in any way, form, or fashion, or it will be a taxable distribution. But it's pretty simple. There's usually a form that has to be completed, and then the IRA administrator will send those QCDs directly to the charity. All right, tip number 5, know the age for RMD. So 72 years of age here for required minimum distribution. So these funds have to come out by law out of that IRA. They're going to come out whether the individual needs these funds or not. It doesn't matter. The government says you're getting your required minimum distribution. However, again, if that individual gives to charity, they can use all or part of their required minimum distribution to donate to charity. It can go straight to your charity of choice. And as a matter of fact, I know some folks who do this on a regular basis. They absolutely love this idea. So if you know someone, your clients, they're around this age, 72, we need to make sure that they are aware of this. They don't have to take their required minimum distribution, get it, and then write a check or then donate to charity. They can send it straight to the charity and bypass themselves, because if they receive that required minimum distribution, they get taxed on it, and they don't have to be if they're giving to charity anyway. Tip number 6, we're back to the charitable remainder trust. So here's an idea. We talked about earlier how these stretch IRAs have pretty much gone away. Well, you can actually use a charitable remainder trust, but I will say this, usually charitable remainder trusts are going to be worthwhile if you're looking at 6 figures. Some organizations will actually suggest 250,000 to start, or at least if they will act as a trustee for a charitable remainder trust. Some $100,000. So I say this because we don't want to start setting up charitable remainder trust for a few $1,000s. There's the setup, the cost, of course, of getting this all prepared, the documents, the advice, and you don't want to just set them up because it sounds like a good idea. You need to have funds in there that make sense for it. But you can use an IRA to have the funds go into the charitable remainder trust. And it will extend for those beneficiaries that we talked about earlier, who now pretty much will not be able to have a stretch IRA. If the CRT, the charitable remainder trust, is funded with the IRA, here's how that would work. It would be set up for a term of years or upon someone's life. And then the remainder of that charitable remainder trust will go on to charity. So in the beginning of that charitable remainder trust, those payments can actually be set up to go to those beneficiaries that no longer have that stretch IRA, but now you can actually have them receive income through this CRT for a number of years. And then at the end of the term of this charitable remainder trust, those beneficiaries, they've gotten their income for, say, 20 years. That remainder that's left in this CRT will then go on to the charity or charities that you have chosen. So there is a way there that you can actually stretch out a bit longer for some of those beneficiaries if you have an IRA. So again, something to think about with your clients. Just know that this is available. So what's a charitable remainder annuity trust? A CRUT or CRAT. In this case, this is a CRAT. The CRUT is actually the unit trust. But the CRAT actually has set annuity payments. So those payments are fixed. Once you set up the charitable remainder annuity trust, the payments cannot be changed. Some people like that and just knowing like every year what they're going to receive. Other people, they want a bit more flexibility. So the flexibility comes in with the charitable remainder unit trust. Every year, the value of that trust is assessed, it's looked at. And then those annuity payments are based on what's in that trust every year. So there's a bit more flexibility with a unit trust. The unit trust also allows you to contribute additional assets once you've set up that charitable remainder unit trust. The annuity trust, once you set it up and put your contributions in there initially, that's it. So the unit trust gives more flexibility. And there's a minimum that has to come out every year of 5% out of that charitable remainder trust. So just know that. All right, why should you consider a CLT? Well, here's something we'll talk about in the proposed legislation coming that we're all hearing about. Some folks with very sizable estates. Right now, the federal estate tax exemption we know is 11.7 for an individual, 23, almost 24 million for a couple. So another thing to think about, if an individual receives a windfall, there's a large lump sum that they somehow come into, or they have a very large estate. Charitable lead trust may certainly be an option for them. So it's just the flip, really, of that charitable remainder trust, where with the charitable remainder trust, the payments go to the beneficiaries first. With the charitable lead trust, the payments actually go to the charity first. So it's almost just the flip. Charitable remainder trust, the charity gets the remainder at the end of that trust. With the charitable lead trust, the charity gets the payments at the beginning of the trust. And then what remains goes on to those beneficiaries. And usually those beneficiaries can receive what's left in that charitable lead trust without that distribution being taxed. So if someone, for instance, I'm going to give you this example here. How much does it take to fund a charitable lead trust that generates $300,000 annually that goes to charity? So every year this trust spends off $300,000, and that's going directly to charity. And it has a 5% rate of return. Anybody have any guesses? How much does it take to fund such a CLT? Well, it's about $7 million. And the reason I know this is because I've actually worked with someone who was very excited. She happened to have a charitable lead trust. And she was excited because it was time for her to get those annual the payments so that she could give and donate to charity. So she was so excited. So it's an option. We need to know that it is available depending on the size of the estate or what the individual is actually trying to put into the trust, but usually for much larger estates. Tip number 8, think about cash gifts in 2021. The CARES Act. The CARES Act, again, deals with new legislation. It came about in 2020 and it extended into 2021. And here's why I think it's important for us as attorneys, practitioners. The provision I will speak about here, there are many, many provisions of the CARES Act, and they touch on all different areas of law. But this one in particular deals with cash giving to charity. In this case, individuals who itemize, they can now in the year 2021, and they also have this option in 22, they can give more to cash, they can give more cash to charity before they reach their adjusted gross income limitation. It used to be capped at 60% of their adjusted gross income if they gave cash to charity. That was their deduction. But in 2020 and 2021, that has been moved up and it's now 100% of their adjusted gross income for 2020 and 2021, which it was extended. So just know that sometimes a big cash gift in 2021 may be beneficial to your client. Now with that, I'm not saying you are well versed with the taxation part, That may be the collaboration. That may be the piece where you make sure you are speaking with their accountants or speaking with someone, their financial advisors, to make sure that the CARES Act, if it's applicable to your client, they may want to make a big gift while they're alive, but you need to be aware that this is actually out there. And it may not be around in 2022 because it was put in place to incentivize people to give during the pandemic. So it may be on its way out. But just know that cash gifts in 2021 to charity doesn't apply to donor advised funds or their sponsoring organizations. Cash strictly, not stocks, not real estate, cash to charity. So know that that exists. Tip number 9, review those beneficiary designations. Make sure that when you're speaking with your clients, make sure that you're coordinating again. If they have financial accounts, they have life insurance, make sure they can actually give to charity through, a life insurance policy. Charitable organizations, they have a unique position. They have an insurable interest on individuals that are involved in their organizations. So you may represent a charitable organization. That's something you may want to know, that they do have insurable interest. Religious organizations, educational organizations, and there are others. Know that this is out there. So again, coordinate with those financial advisors regarding those retirement accounts, those beneficiary designations. Charity, again, as we touched on earlier about the IRA, it may be a better gift to give to charity than to an individual. But just know, beneficiary designations are important regarding their charitable gifts as well. And for the code, we are going to share for the CLE. The code is 2519NC. And that's for the CLE pending. The code is 2519NC. All right, and the last tip, just keep abreast of this upcoming legislation. It is moving quickly. We'll see how things go, but there's a STEP Act, the step up in basis, capital gains, all of that may change. And so the federal state tax exemption, that also is being looked at, it maybe being lowered. We talked about it earlier, it's at 1.7 million. And also keep in mind, there are some states, Maryland has a state tax exemption. So be aware of these things. These things are up and moving right now. We're not quite sure where they're going to land, but they are certainly being talked about and they're proposed. The ACE Act, donor advised funds. They're thinking about changing the payout requirements for donor advised funds. Currently, donor advised fund account holders, they have absolutely no payout requirements. Once they make a contribution to their donor advised fund, those funds can stay in there right now indefinitely. So all of these things are in the pipeline. They're being looked at. Make sure you're up to date on these proposed legislations. And thank you all for joining us. Those are my 10 tips to join with Amy Griffin's 10 tips, top 20 tips for attorneys.
Fantastic. Bravo, bravo. Great job, Aquanetta. That's really great information. I have clients very often who come to me who do have growing and large tax deferred qualified accounts, IRAs, 401ks, and those kinds of things. And we always have to be very careful how we're planning around how they choose to distribute those assets to different people. So great information, talking about these charitable trusts, and the Secure Act and everything that's in many ways high level stuff, but we need to know it because our clients are being faced with those things. So thank you so much. Thank you for sharing that CLE code. Hey, everybody, listen, I just want to thank you all for joining us today. Today was day 2 of our estate planning awareness event week, or awareness week events. And we have one more day, which is tomorrow. Before I talk more about that, I want to make sure I thank our sponsor. We're so grateful to the Black Women Attorneys of Maryland who have sponsored today's CLE. Just dynamic and just wonderful. We're grateful to them and that wonderful organization and all that they're doing. for attorneys, and certainly for Black women attorneys. I think it's dynamic and I think it's fantastic. So thank you, Aquanetta. Thank you, Amy, for wonderful presentations. There is a question here. Amy, are you still with us? Are you able to come on really quickly just to answer this one question, and then we'll get out of here? If an elderly person is brought in by a relative, do you allow that relative to be present during the consultation or once legal engagement? If the client wants a relative present and the client has capacity, but doesn't remember the names of everyone who is to receive a bequest. So basically, do you allow this person who may have some kind of cognitive challenge, do you allow people to be in the room with them when they come to meet with you?
I really work very hard to make sure that they are not. I try to have conversations, but the reality is there are times when they are there, especially when we're Zooming everything, so that we know that they are nearby. But by and large, I try to make sure that I have at least one conversation without anybody else present, or any of their family members present, or the person who could be doing undue influence, to try to gauge indeed if there is some undue influence. I try to make sure I have at least one time where I can have that conversation.
Good stuff. Great answer. One of the things I often tell people, in addition to the undue influence concern, I tell the people who are there with them, this is really a protection to you. Somebody shows up later and say you coerced them, I can say you weren't even in the room, so maybe that works, maybe it doesn't, but great information. Hey, we're going to get out of here, everybody. Thank you again, Amy and Aquanetta. Thank you all for joining us. Listen, come back tomorrow. Tomorrow's the last day. It's all about building wealth in the Black community. So you want to be here. We have a panel of attorneys who'll be here talking about that and sharing tips and ideas and things that you want to know. For that purpose, I want to thank Vice President Lamont Bailey for coming on and sharing with us on behalf of the NBA. Great job. Register, you all. However you found out about this, go back to that same advertisement. There should be a link there for tomorrow's event. Make sure you register. Same time tomorrow, 11:30. We'll get in, we'll get out. We'll share great information. We're going to close out there. Thank you again, everybody. We'll see you tomorrow.